Hi, everybody. Right now in my hands, I have the Juror Handbook, and I just opened up to the first page. What I want to do is I basically want to read it, but I want to summarize it. I'm not going to read the whole thing to you, but I'm going to read it, and then as I get through each section, I'll go over the underlined main points. And so if you haven't had time to sit down and read it, or for whatever reason you didn't get through it, didn't get to it, this might be just an easier avenue for you to get the content. So immediately when I open to the first page, I'm on page 4. And the first thing that strikes me is a little blurb from the Northwest Ordinance. So one thing I just wanted to reiterate is we don't stand under the Constitution. The Constitution is our contract with our federal government service providers. And those service providers historically were American. They were British territorial, and then it was the Papist municipality. And so we have contracts with each of them. So the American Constitution was 1787, the British Territorial Constitution was 1789, and then the Papist municipal contract was 1790. And so there's 3 different constitutions. And so the reason why we had those was because they provided us services. When we had the revolution, afterwards, we didn't have a navy. We had merchants, and we had a fleet of merchants, but we weren't going to go out on the high seas and navigable in waterways and defend ourselves. We just didn't have it. And so that's why we contracted that with the British king, King George III, and he was happy to have the contract. The other thing that we did in 1790 was as far as a postal union and having mail that went around the world that was supplied to us by our papal contract. So when you look at the Pope, it was the clergy that started the mail routes back in the day. And it would be going from, the brothers would travel and take the mail with them, and that's how it all initiated. And so we contracted to have our post globally handled by the church, essentially. And so when you look at this little blurb in here about the Northwest Ordinance, it says the inhabitants shall be entitled to the benefits of judicial proceedings according to the course of common law. No man shall be deprived of his liberty or property, but by the judgment of his peers or the law of the land. And so that's the Northwest Ordinance right there. The phrase law of the land is lifted from the Magna Carta and means due process. So the law of the land is due process. And due process means you being given a chance at a time or a date. If there are trespasses being stated against you, then you have a time and a place to go speak to those trespasses and defend yourself. And nothing happens without you having that opportunity to defend yourself. And if there is a trial, then it is going to be by a trial of your jurors, and they listen to the facts of the case. And they look at if you were given due process, if you have been able to defend yourself, if you've been able to speak to the facts of whatever the trial is about, whatever charges or trespasses were put against you. And so the phrase law of the land is lifted from the Magna Carta. It means due process. Common law is not a list of laws, but a way of life that affords the demands of fair play. And we know that fair play is you getting your due process in court. And so all of that is called due process. Okay, so a couple of things from just the first couple pages. A common law judge is never to tamper with the juror's conscience, substituting his knowledge for the juror's knowledge. Finally, in no sense is the jury a majority or a democratic institution. By only one juror disagreeing with the other 11, he hangs the fire of the jury's verdict and stops the government from taking the life and liberty and or property of the accused. So right there, the judge can give you all kinds of directions, and he's giving you directions before you've heard the facts of the case. So it's kind of like jurisprudence, like he's assuming and presuming you haven't even heard anything yet. So if he's giving you instructions, you know, your point of being there is to listen to the facts of the case and to make a decision on your own conscience. And so you cannot be swayed by the other 11. And if the other 11 are thinking one way and you're thinking the opposite, you have to be true to yourself and you have to stick with your conscience, and nobody else can tell you any different. And you take an oath to sit there and to do your absolute best in judging those facts and arriving to a conclusion. And you cannot be coerced into a decision that you feel is wrong, if that makes sense. So the foundation of our common law jury is freemanship, understood aright in the history of our tradition. The common law juror is not civil law's citizen, one sworn to loyalty to the state. But rather is a free man, one freed to do right upon his oath. And ultimately, you obey truth, and you are putting yourself in the hands of your maker if you do not. On page 8, they talk about a runaway grand jury. And at this point, the grand jury has its power to investigate and powers of investigation. So you can look at the government employees, you can look at the prosecutor himself. And during the 19th century, many American grand juries knew their sworn duty and thus were independent, refusing to substitute the prosecutor's will for their own reason. And then he states, nowadays, you have many grand juries that look at the prosecutor and they want direction. They want to be told what to do. They trust him. And so that's something that we need to do, is we have to make sure that people know their power. On the bottom of page 9, it says, remember, judges give instructions to the jury before the jury deliberations, before the juror has decided the facts of the case, and before he has a fuller understanding of the facts, the law, and how it ought to apply to those facts. Thus, a judge's instruction, like legislation, are speculation at best. Both the grand juror and the petit juror must take care never to allow the government to act in violation of the Constitution. At bottom, the juror is impaneled to withhold permission or to give permission to the government to use force against another, meaning they're going after someone for their property, their life, their liberty. The juror must remember that in criminal cases, only intentional or grossly negligent injury to another is injustice. Consequently, the juror ought to never give permission to the government to act against life, liberty, or property of a defendant unless the evidence shows that he callously or willfully injured another. In a criminal case, any statement of mere men, legislators, bureaucrats, prosecutors, judges, that a certain behavior is criminal is true only where two things are true. The defendant intentionally caused injury to another, and God's word agrees that he should not have. Remember, any man at his best is still only a man. So he has no right to decree that which another has done to be wrong unless nature's law unwritten, and we discussed natural law in a different video, or nature's God, law written, shows that it is. So to sum things up, the juror binds himself in obedience to find truth and render up the verdict according to the truth, to decide the facts, to discern the application of the law to those facts, and in a criminal case, to declare the defendant's guilt or innocence. Our common law takes the juror as he is and allows no time between his answer of the summons and his impaneling to teach him more. So we don't sit there and like overeducate our jurors and try to sway them or lean them or bias them in any way. Consequently, the defendant in a criminal case throws himself on whatever knowledge, instinct, guts, gravel, and grit the juror brings to the jury box. So these are men and women that are a part of our community that we bring in and have them be a part of this jury. And we don't try to sway them or sway their conscience or overeducate them to bias them in any way. In fact, where the juror is convinced that a law is unlawful, his duty and oath demands that he disregard that counterfeit law and acquit the defendant, even if doing so is contrary to his oath to obey the judge's instructions. Why? Because no oath ever binds a juror to deliver a verdict contrary to the truth or right. It bears repeating, no one has a right to do wrong. Simply put, no government-made law can give government a right to do wrong, and every juror must stop government from doing wrong. To do so is the heart of the juror's duty. And so if there were suddenly a law put on the books that you couldn't go to church, and if you went to church, you would be arrested and put in jail, and you had to pay fines. That's not a lawful law. You know, we know that. If there was a law in the books that if you broke into someone's house, you would have to go to jail because you broke into someone's house and you trespassed on their property. Well, what if you broke in that house because the house was actually on fire and people were sleeping in that house and you were trying to rescue them? Should you be put in jail and fined because technically you broke into their house? So this is why you have to have people to actually look at the facts of the case and decide if trespass was done, because you can't have someone that blindly follows a law without having a brain in their head to think. So consider the following reasons for never following in blind obedience the jury instructions. First, our law will never punish the juror that disregards the judge's instructions concerning the law, whether obeying those instructions brings about a wrong or disobeying brings about a right. Why? Because the juror, by following his conscience, has done no wrong in the eyes of the law. In fact, he has done right. Mary Stanley. Hold on. Okay, so I got interrupted and it was a long conversation, but I know that we were going over the following reasons for never following in blind obedience jury instructions. So first, our law will never punish the juror that disregards the judge's instructions concerning the law, whether obeying these instructions brings about a wrong or disobeying brings about a right. Why? Because the juror of the following, by following his conscience, has done no wrong in the eyes of the law. In fact, he has done right. Although the juror should ponder the judge's instructions, he must never substitute the judge's instructions for his own conscience. No judge, but God alone, is Lord of the individual conscience. So further, the juror will never answer to the judge for his verdict, but he will answer to God alone. Second, the juror's power of the verdict shows that the juror has authority over the law. Indeed, if the juror did not have this power, the judge would ask the jury to decide only the facts, and then using those facts, the judge would apply the law as he understands it and would render the verdict. The jury, however, has the power of the verdict. In fact, even if the judge directs the jury to deliver a certain verdict, the juror, by our law, need never do so if he disagrees in good faith. Again, if this were not so, the judge would not bother to direct the juror's verdict, but would simply decide the verdict for himself. The third one is in promising to keep his oath to obey the judge's instructions concerning the law is justifiable and indeed ought to presume that the judge will instruct him aright and not lead him astray. You know, you take the oath to follow the instructions, but you know, men are men and people can be led astray. You can have a judge sitting on the bench that has the greatest intention, but ultimately the juror has to obey their own conscience. And so, in short, judges are mere men who at their best are still only men. So by contrast, the true juror never seeks the juror's seat. You know, they're asked to impanel the jury. And so they're not gaining anything out of it. And you know, one might gain something from being a judge. So fourth, no juror is fully able to understand at first glance or even after pondering a judge's set of jury instructions. In fact, the judge himself cannot be said to fully understand the applicable law in the case. He therefore powwows with the parties' lawyers, hoping to find a consensus of what law rightly applies to that case at hand and how it applies. Even these experts at law seldom fully agree, piling instructions upon confusing instructions, leaving the juror to his own judgment. You know, where the experts disagree, the juror is free. Fifth, as with all other duties in this life, every juror will answer to God for his decisions, and he has no refuge in the instructions of a judge, according to one Supreme Court justice. You know, the judge is just an employee, right? So sixth, it is more likely that the juror has something many judges lack, and that's balance. So early on, where the common law tradition found truth was out of balance, it was called bias, an old law French word from the Normans. Among other reasons, the juror is necessary in the event that the judge is less than neutral and that there is bias. So I'm on page 18 and we're about ready to wrap up this first section of the juror handbook. And I'm kind of relieved because I have been searching through common law, excellence of common law, and I have been searching through the commentaries on the laws of England. And I'm just looking for somewhere where someone has written down the first principles of common law, or where they have written down like the maxims of common law, because I know there are maxims in civil law that completely correlate to the maxims in common law. But for somebody just to spit those things out and to be upfront and here they are, it's really hard to find somebody to nail that down for you. And even when you look at scripture, like the first principles are, you know, buried in scripture. And so I have some relief. Here's my frustration. The refinements of our common law tradition occur case by case as jurors and appellate courts render their findings. Blech, I know, but where are all these cases for me to read so that I know what it is? So frustrating. So when you go over to page 19, it says, behind each provision of the Declaration and Constitution is a first principle of common law, which that provision draws from the laws of nature, natural or general revelation, and nature's God, special revelation or scripture, and a brief explanation. So the reason for any given provision of these two documents is always the same in one respect: to bind government to limits so that men will be free. History is clear. Government, if allowed, will violate these limits. So such is the nature of the beast we call government. It is the juror's duty to stop the government from transgressing the boundaries of these two documents. So I'm feeling that we're just going to have to go into the Declaration of Independence and the Constitution, and we're just going to have to break them down. And I got them over there, like they're right behind me, so no problem. And I can read cursive, so. Okay, to end this first chapter, it says, no country has ever conclusively lost its freedoms while using the common law jury. Every country that has lost its freedoms was unwilling to entrust such power in the hands of a dozen men drawn at random from those around the courthouse. As a juror, you are America's last line of defense for freedom. Our common law has empowered you to stop the runaway, lawless state. When you are called to duty, you must be armed and outfitted to the task. Meaning, we're going to study our Constitution, we're going to study the Declaration of Independence, we're going to break that down, and we're going to know exactly what those first principles are. And we are going to go in and serve as one of those 12, and we are going to keep our Creator in our minds, and we are also going to be very interested in truth and facts, and we are going to respect our own conscience and go in and do the work. So that's chapter 1, y'all.